And greetings. Welcome to Fraudulent Conveyances and Transfers, the diminution of debtor to the detriment of the creditor from American Jurisprudence. We'll be going over this, and I'm hoping to make this into two parts. The first part, will be going over the general concepts of this, and the second part, we'll look at a little bit more of how this can apply and where the rubber meets the road. We'll also have at our ready Black's Law Dictionary 9th edition at our side to make sure we leave no word behind. And with that said, we're going to get started. Before we do, I just want to remind everyone this is strictly for entertainment educational purposes. This production broadcast is not to be used for anything for your professional, personal, legal, lawful, or financial use. Don't do this at home. That being said, hey, welcome everyone. We got Captain Jack here. Kara, welcome. And with that, I'm glad everyone was able to get the notification. That means we can get right to work here. So first, we're going to be going over the general definitions. This is, by the way, from the November 2022 update. And welcome, Katie. Good to see you here. All right, and with that, let's see here. I think I got all my... Everything's displaying well. Let's continue. If sound sounds good out there, I'll proceed here. Section 1. General definitions. Although one can generally dispose of his or her property as one sees fit, a person cannot frustrate his or her creditor's rights and avoid obligations by changing title to his or her assets. The fraudulent transfer of assets is considered a tort, and preventing the avoidance of obligations in this way is the point of an action under the fraudulent conveyance law, which is a tort action distinguishable from ordinary fraud. So we're looking for some kind of monetary damages here. Thus, the purpose of a fraudulent transfer claim is the removal of obstacles which prevent the enforcement of a judgment. State fraudulent transfer law generally attempts to protect creditors from transactions which are designed to or have the effect of unfairly draining the pool of assets available to satisfy creditor claims or which dilute legitimate creditor claims at the expense of false or lesser claims. Now, that's a big earful here. Remember, we're just getting into the introduction here and the general definitions. And please stay with it because American Jurisprudence in this particular publication really does have a great way of breaking this down so the most common understanding can be achieved from this. Let's proceed. A fraudulent conveyance or transfer is a transfer by the debtor of a property to a third person undertaken with the intent to hinder, delay, or defraud his or her creditors by preventing a creditor from reaching that interest to satisfy its claim. So that's your lawsuit there, their claim, or by effecting insolvency on the part of the transferring entity. So it is also defined as a transfer made without fair consideration by a debtor. Hang on a second. It is also defined as a transfer made without fair consideration by a debtor when he or she is insolvent, or which renders him or her insolvent by a defendant in an action for money damages who is unable to satisfy the judgment that the plaintiff finally obtains. Now, this is a good one here. Footnote 12. Let's run down to footnote 12 really quick because we skipped over a lot. We'll have to get to it. This is just a case holding here. Let's see, applying Virginia law. Okay, so that's it. Let's continue. Fraudulent conveyance is, at its core, a diminution of the debtor's estate to the detriment of the creditor's right of realization. It prevents debtors from placing property beyond the reach of their creditors when those assets should be legitimately made available to satisfy creditor demands. Consequently, if a debtor disposes of property, whether it be real or personal property, so I believe when we're saying real property, we're talking commerce as opposed to personal property, or goods or titles. So goods would be manufactured, right? And titles would be legal claim to property with the intent to delay or defraud his or her creditors. The disposition may be set aside. So that's if the debtor disposes of the property with the intent to delay or defraud, right? The disposition may be set aside. Furthermore, debtors are prohibited from transferring substantially all of their assets to another to defraud a creditor or avoid a debt, especially where the transfer is not supported by adequate consideration, again, consideration of both parties here, or when a general scheme or plan to strip a debtor of his or her assets is made with no regard to the needs of creditors. The laws of fraudulent conveyances protects creditors, not debtors. However, as we get through this a little bit more, we're going to find that there's actually some other ways of protection in here for both parties. And that's kind of why this is a bit of a provocative topic for many. But as we go along here, you're going to start to see really how it's constructed in a way that really does reflect to keep things on the up and up as far as honesty and truth goes within the context of credit. Let's continue. So in the context of common law fraudulent conveyances, the fraudulent conduct is not in dishonestly inducing a creditor to extend a debt, but rather is in the acts of concealment and hindrance. So there we go. In the context of the common law, right? It's not in dishonestly inducing a creditor to extend debt, but rather it is the acts of concealment and hindrance. Let's keep this in mind. Acts of concealment and hindrance. Personal property as intellectual property. Depends how you're using it, right? So intellectual property is quite commonly considered commerce, used in commerce, and owned by corporations. So I wouldn't say it is in every context, but perhaps it could be in as personal property too. Although I've never seen it really used as personal property. Although ultimately it originates there, so who's to say? I think that just steps into when you start to get into intellectual property law. That's a whole other topic that we should probably go into at another time with American jurisprudence, because we have some volumes on that too. I digress. Let's continue here. So we have a lot of these case holdings. Let's look what we have here. The law of fraudulent. Oh, let me move this over a little bit here. The law of fraudulent conveyances is also distinguishable from other doctrines. For example, assignments for the benefit of creditors. As to the nature of assignments for the benefit of creditors, see AmJur, assignments for okay, excellent. So that's another interesting one to look at there. Assignments for benefits of creditors. I'm not sure if I have a digital copy of that, but I believe I do have it in the hard book cover. Let's see what else we have here. As to a transferor's intent to hinder or delay creditors, see Section 9. Okay, as to the necessity and effect of a lack of consideration, see Section 26. Excellent. Let's see here. We're going to skip to 26 really quick because I don't think we're going to... Oh, shoot. Sorry about that. Let me fix something here really quick. And we're already starting here. Let me just fix this really quick while we're doing this in the background here. here. All right. Sorry about that. Sometimes it gets a little wonky here, and I try to jump around hyperlinks through the document. All right, one more time here. Yeah, while we're here, if everyone could hit the like, would be a great time to do it. And let me get this thing back in line here. Come on. All right, one more time here. We have to refresh the whole thing. And here we go. All right, it's coming back now. Okay, let's get back to this. Here we go. We got one more. We fit this on here. Let's see if this still fits. Nope. See there. Okay. Oh, one more time here. Give me a hard time. All right, there we go. All right, hang on. Now it's really getting a little wonky on me here. Give me a second here. All right, that's a little bit better now. Okay. Thanks for bearing with me there. And let's get back to this here. So we're just at the end of this here. Lack of consideration, section 26. We're not even going to go there now. We spent too much time trying to jump there out of order. We're going to stick with the plan here. So again, we're going over the November 2022 update of American jurisprudence. And now we're going to go over section 2, types of actionable fraud. Oh, okay. It's pretty straight up on this one here. The courts and statutes recognize different types of actionable fraud. Actual fraud, is sometimes called fraud in fact and constructive fraud, which may also be called fraud in law. So we have, wow, different types of actual fraud. There's actual fraud or fraud in fact and constructive fraud or fraud in law. Okay, a creditor's bill to reach a debtor's equitable assets, also essentially known as equitable fraud, has largely been displaced by the state's Uniform Fraudulent Transfer Act. Practice tip, pay attention. In some states, whether the creditor is pre-transfer or post-transfer, will have a bearing on which type of fraud must be shown. So if it's pre-transfer or post-transfer, will depend whether it's an actual or fraud in fact or a constructive or fraud in law. All right, so that's a good takeaway, guys. Pre-transfer or post-transfer will have a bearing on which type of fraud must be shown to have good standing. Cases, common law term, actual fraud is broad enough to incorporate a fraudulent conveyance. Nice. All right, end of that supplement. Let's continue on here with the footnotes. Transfer made or obligation incurred by a debtor is fraudulent as to the creditor, whether the creditor's claim arose before or after the transfer was made or the obligation was incurred. If the debtor made the transfer or incurred the obligation with the actual intent to hinder, delay, or defraud any creditor of the debtor. So we get that from the Fraudulent Transfer Act, Uniform Fraudulent Transfer Act. That's a UFT. All right, so now we're on to cognizable debt requirement. To void a transaction pursuant to a state statute rendering transfers by insolvent transferors void as to creditors, there must be a showing of indebtedness to the creditor at the time of the transaction. In other words, a debtor-creditor relationship is necessary. You get this? So we need to have a necessary relationship between a debtor and creditor. The existence of a debt is a requirement for bringing a fraudulent conveyance action. So we had to have an existence of a debt to have a fraudulent conveyance in the first place. And generally speaking, the awareness of probable legal action against a debtor amounts to a debt. You get that? Probable legal action against a debtor amounts to a debt. Thus, an existing debt is an existing legal liability, whether matured or unmatured, liquidated or unliquidated, absolute, fixed, or contingent. Furthermore, where payments are fixed and obligations are certain, set over a period of time, and subject to judicial enforcement, they are considered debts under fraudulent conveyance law. So now we're looking at the definitions of debt under fraudulent conveyance laws. Contingent debts are counted in determining existing debts. So contingent on what's going on here, and there's existing, which are already on the books, for the purpose of ascertaining whether a debtor is insolvent on the ground that the value of the debtor's saleable assets is less than the amount that will be required to pay probable liability on existing debts as they become due. So that's your contingent debts. Under the Uniform Fraudulent Transfer Act, a debt means liability on a claim, and the definition of a claim includes unknown and unasserted claims. A claim must be an enforceable obligation. Pretty powerful stuff here, because remember, this Uniform Fraudulent Transfer Act applies over what used to be determined through equity. It is not necessary that a debt, for the purposes of fraudulent conveyance law, be reduced to judgment. And in fact, pending lawsuits have been treated as existing debt. A second here. Yep, just one moment, guys. I had a little issue here with the chat. I just want to get this all. Oh my gosh. Yeah, we got a lot more going on here in chat than I even saw. Great. All right, guys, welcome. Hey, we got Joe Cool here. Checking in. Get the notepad out, Joe Cool, and let's continue, everybody. All right, so remember, we're talking about fraudulent conveyances and what's recognized as debts. And we have contingent, existing debts, and let's look at this one here. It is not necessary that a debt, for the purposes of fraudulent conveyance law, be reduced to judgment. And in fact, pending lawsuits have been treated as existing debts, although it has been held that a spouse's continuing obligation of support is not an existing debt. In one jurisdiction, to prevail in an action for a fraudulent conveyance, the conveyor must be a defendant in an action for money damages, or a judgment in such an action must have been docketed against him or her. So, if this makes sense to everyone here, in one jurisdiction, or give an example here, to prevail in an action for a fraudulent conveyance. Remember, conveyance, transfer, moving, ownership of property. The conveyor, the one moving it, must be a defendant in an action for money damages, or a judgment in such an action must have been docketed against him or her. Okay, so we need to know that we had there had to been an action for money damages to even bring an action for fraudulent conveyance in one jurisdiction that they're mentioning here. And that would be 13. So now we went on there. That's First Keystone Consultants Incorporated versus Schlesinger Electric Contractors Incorporated, and that's New York, apply New York law. And see, overturns is for a state statute, uniform, of course, Uniform Fraudulent Transfer Act. All right, so what we see here is that there's jurisdictional intricacies to these. However, there is that one thing that if you're ever involved in this Uniform Fraudulent Transfer Act, that's something to look into further. All right, let's continue here. All right, we're on to the Uniform Fraudulent Conveyance Act and Uniform Fraudulent Transfer Act. So I'm going to save you the trouble. We're going right to it here. Under either the Uniform Fraudulent Transfer Act, UFTA, and the Uniform Fraudulent Conveyance Act, UFCA, were adopted, which is pretty much everywhere here in the United States of America. The rules of fraudulent transfers and conveyances have been codified as they existed at the time of the respective acts' adoption. However, the Uniform Fraudulent Conveyance Act has in fact been revised, modified, and in certain jurisdictions, repealed by the Uniform Fraudulent Transfer Act. Whew. As to the Uniform Fraudulent Transfer Act, although it provides a broader range of remedies than the common law, the Act is largely an adoption and clarification of the standards of the common law of fraudulent conveyances, which is a good thing. Indeed, the remedies of the Act and its predecessor are cumulative to the remedies applicable to fraudulent conveyances that existed before the uniform laws went into effect. However, it has also been held that to the extent that the facts undergirding an UFTA claim also establish other recognized causes of action. For example, breach of contract, negligence, or common law fraud. A creditor may pursue that claim as well. Wow. Not all common law remedies related to fraudulent conveyances are preempted by the Act. Wow. So we're looking at it not being a fully comprehensive covering of all remedies to fraudulent conveyances. So there still are common law remedies. Interesting. The thrust behind both statutes appears to be that a fraudulent transfer, all right, here we go, occurs when a debtor conveys title to assets to a third person for the purposes of placing the assets beyond the reach of creditors. And regardless of whether a state has adopted either model law, general equitable principles still apply. Get that? Whether the state has adopted either model law, general equitable principles still apply for looking at fraudulent transfers. Even when a state has adopted neither uniform law, the purpose of its fraudulent conveyance statutes has been held to be put in the creditors back in the same position they would have enjoyed immediately prior to the voidable conveyance. So the purpose of its statutes, right, has been held to put the creditors back in the same position they would have enjoyed immediately prior to the voidable conveyance. You get this? This is something I've heard quite often in the past, to put creditors back in the same position they would have enjoyed immediately prior to the voidable conveyance. All right. So let's kind of get through the next section here. Okay, as the Uniform Fraudulent Conveyance Act. Now we're on to the Conveyance Act from the transfer. So the transfer recovered from debtors, purpose to provide creditors the means to satisfy debts using assets, right? So it's mostly the Uniform Fraudulent Transfer Act is there mostly to protect creditors. Then we have, as to the Uniform Fraudulent Conveyance Act, one court has held that it seeks to strike a balance between the need to permit transactors to make deals, some good and some not so good, and the need to fix a point beyond which courts will not permit grantors to enter into transactions that will too profoundly impair their ability to discharge obligations to creditors. This gets in a little bit more complex purposes here. The Uniform Fraudulent Conveyance Act is to be repealed by states enacting the Uniform Fraudulent Transfer Act. As to the impact of the Bankruptcy Code on the Uniform Fraudulent Conveyance Act and the Uniform Fraudulent Transfer Act, see AmJur Bankruptcy. Interesting. All right. Hey, we got Nubs. Welcome, Nubs. Good to see you here. We're on here about fraudulent conveyances, and I'm going to try and get that fully off the screen, but it doesn't want to go. There we go. All right. All right, we're done with these footnotes here. Certificate of appealability. Okay. These are all just the case holdings. And we're going to go on to the general principles of construction of statutes, retroactive effect. Let's see here. I think I wanted to get to another part here. Go over the bankruptcy stuff here. So we're going to get into stuff that we're probably not ready to cover yet. Let's see what this section is here. Let's see here. Generally. All right, this is a good one we're going to read, and then we need to get that section 26. Okay, the determination as to whether a fraudulent conveyance has occurred is made on a case-by-case basis, based on the facts and circumstances of each case, and depends on the conditions that existed when it was made, as there is no precise formula for determining whether a transaction was a fraudulent conveyance. So there's no precise formula. So what are we going to look at in a case by case? We have a few factors here. We have the facts of the case and the circumstances. Now we want to look at conditions of the case, which means conditions are addressing things that are uncertain. When it was made, the conditions when it was made, important. And the transaction between two parties was a fraudulent conveyance. In addition to considering the facts and circumstances, it also considers other elements and factors, such as choice of law, as well as whether there was a creditor, either present or future, to whom a debt was owed, and who was defrauded concomitant with a debtor intending fraud. Additionally, a court may consider whether there was a conveyance of property that could have been applied to the payment of the debt, whether the plaintiff or the creditor sustained damages caused by the alleged fraudulent transfer, and whether the transfer was made in haste. So let's get this thing set up here. Observation. These are the best parts I love about the AmJur. The time of the conveyance is the relative time for determining if the debtor has made a fraudulent conveyance. So the time of the conveyance is the relevant time. So the time of conveyance is a relevant time for determining if the debtor has made a fraudulent conveyance. In some states, depending on whether the creditor is pre-transfer or post-transfer, will have a bearing on which type of fraud must be shown, right? In the case of pre-transfer creditors, the creditor need only show badges of fraud, to establish an inference of fraud, whereas post-transfer creditors must show fraud in fact or an actual intent to defraud. Remember, the fact comes with the post-transfer. That was the distinction we learned earlier. Excellent. And that's why I say the nice thing about AmJur is how they pull all this together. It seems like a lot of random facts, but then they start to assemble the puzzle pieces here, and you see how it all starts to make sense. So yeah, post-transfer is relying on the facts here, and the pre-transfer is on law. So we have the cumulative supplement here. All right, let's read these because these are great. Common law fraudulent conveyances, although a fraud, do not require a misrepresentation from a debtor to creditor. Remember the part about the misrepresentation. It's not the action. The cause. Conveyance which hinders, delays, or defrauds creditors shall be void as against the recipient unless that party received it in good faith and for consideration. Conveyance which hinders, delays, or defrauds creditors shall be void as against the recipient unless that party received it in good faith and for consideration. Pursuant to the Uniform Fraudulent Transfer Act, the creditor is to demonstrate that, here we go, 1. There was a creditor to be defrauded. 2. A debtor intending to defraud. And 3. A conveyance of property which could have been applicable to the payment of the debt due. Same elements will suffice to satisfy requirements of the constructive fraudulent transfer provisions of the Bankruptcy Code and of Pennsylvania's Fraudulent Transfer Statute. All right. So let's move on. This is some pretty good stuff here. Conveyances must be evaluated in context, and where the transfer is only a step in a general plan, the plan must be viewed as a whole with its composite implications. Nice. All right, Puerto Rican law. Nice. 1997. Okay. Constructive fraud, fraud in law. All right, we got to go over these because we had our fraud in fact and fraud in law. Let's do this. Unlike actual fraud, constructive fraud is essentially unconcerned with intent. Instead, focuses upon economic effect. Nice. And involves an analysis of objective factors. Constructive fraud thus constitutes legal fraud irrespective of actual intent. For a constructive fraud claim under a state's version of the Uniform Fraudulent Conveyance Act, a plaintiff must allege that there is a conveyance without fair consideration, or alternatively that the transferee received less than reasonably equivalent value for an exchange at issue, and that 1. The transferor was insolvent at the time of the conveyance, or will be rendered insolvent by the transfer in question, or 2. As a result of the transfer in question, the transferor is left with unreasonably small capital to conduct its business. Or 3. As a result of the transfer in question, the transferor intends or believes that it will incur debt beyond its ability to pay. A finding of constructive fraud pursuant to debtor and creditor law may be predicated upon proof of insolvency and lack of fair consideration without a showing of actual motive or intent to defraud. To avoid a fraudulent transfer, the plaintiff must show that 1. There was a transfer, 2. There was for less than a reasonably equivalent value, and 3. The debtor was insolvent. Constructive fraud has also been said to occur when 1. Look at this, a voluntary gift is made. 2. There is an existing or contemplated indebtedness against the debtor. And 3. The debtor has failed to retain sufficient property to pay the indebtedness. However, it has also been held that under the Uniform Fraudulent Transfer Act, there is no requirement that the transfer be voluntary. To prevail on a claim of constructive fraud under another state's Uniform Fraudulent Transfer Act, a bankruptcy trustee is required to show that the debtor received less than reasonably equivalent value in exchange for the transfer made to the defendants, and that the debtor either 1. Was about to engage in a business transaction for which the debtor had insufficient assets in relation to the transaction, or 2. Intended to incur or reasonably should have believed that he or she would incur debts beyond his or her ability to pay. Another court has ruled that a creditor will succeed under a constructive fraud theory if the creditor shows 1. That the transferor was indebted to the creditor at the time of the transfer. 2. That the conveyance was voluntary. And 3. That the grantor failed to retain sufficient property to pay his or her indebtedness to the creditor in full, not merely at the time of the transfer, but also in the final analysis when the creditor seeks to collect the debt. Interesting stuff here. Transfer made or obligation incurred by a debtor is fraudulent as to the creditor, whether the creditor's claim arose before or after the transfer was made or the obligation was incurred. If the debtor made the transfer or incurred the obligation through an actual fraud or constructive fraud. So the prohibition of constructive fraud operates to avoid transfers motivated by generosity rather than fraud. So all that is to get this through to you in a legal sense, lawful common law sense too, that there's ways to get around certain kinds of contractual relationships, and this is the really operates to avoid transfers motivated by generosity, right, rather than fraud, by reflecting the policy that an insolvent entity or a person should be just to his or her creditors before being generous to others. So that's kind of where this comes in to keep everything in its own lane, it seems, but important stuff to know here. So we're going to look at this cumulative supplement here on the cases under Florida's Uniform Fraudulent Transfer Act. A transfer is fraudulent under the theory of constructive fraud if the transferor does not receive reasonable value in exchange, and the transferor either one was engaged or was about to engage in a business or a transaction for which remaining assets of the transferor were unreasonably small in relation to the business or transaction. 2. Intended to, believed, or reasonably should have believed that he or she would incur debts beyond his or her ability to pay them as they became due. Or 3. Was insolvent at the time of the transfer. And this comes from a 2013 case in Florida. So that's the end of the supplement there for that. And let's see, these are just the case holdings. And the next section is mutual fraud intent. So let's see here. I want to get to that section 26, so we're going to have to zoom ahead here because we're getting kind of late on this. Just want to see what, make sure we're not going to pass anything else I want to go over on this part here. All right, let's see here, badges of fraud. Let's get this down. Certain circumstances relating to defrauding creditors are characterized as badges of fraud because they are circumstances tending to excite suspicion as to the conveyance, which, standing unexplained, may warrant an inference of fraud. In other words, badges of frauds are circumstantial evidence from which intent may be inferred. Indeed, certain circumstances are so commonly associated with fraud as to have earned the title badges of fraud. And when present in sufficient number, they may give rise to an inference or presumption of fraud. Badges of frauds can also establish prima facie a case of a fraudulent conveyance. Badges of fraud, therefore, are circumstances that are so frequently accompany fraudulent transfers that their presence give rise to an inference of intent. The test is whether there is a satisfactory explanation for the circumstance, which may be inferred by a failure of the parties to testify. Wow. Badges of fraud, the test is to whether there's a satisfactory explanation for the circumstance, which may be inferred by a failure of the parties to testify. Because remember, it's circumstantial evidence, circumstances. So failure of the parties to testify or to produce available explanatory or rebutting evidence. Beautiful. Badges of fraud are therefore facts which call for an explanation. Due to the difficulty of proving actual intent to hinder, delay, or defraud creditors, the pleader seeking to set aside a conveyance based on an actual fraud under New York law is allowed to rely on badges of fraud to support his case. That is, circumstances so commonly associated with fraudulent transfers that their presence gives rise to an inference of intent. Now it's 2014. Wow, a lot of them here. Under California law, there's no minimum badges of fraud that must be found in order to prove intentional fraudulent conveyance. Badges of fraud that do not implicitly suggest fraud, but do suggest that there must have been a motivation other than the transaction itself, because it was not economically rational decision for a debtor to make, but for its effect to hinder or delay creditors for the purpose of fraudulent transfers. Okay. 4 factors Texas court to check the legitimate purpose. See here, was made pursuant to standard business practices, arm's length transaction, voluntary or effective forced upon debtor, and was for proper consideration. Judgment creditors' fraudulent conveyance claims against judgment debtor defendants were pled in sufficient detail to satisfy the heightened particularity requirement for pleading fraud or mistake. Judgment creditors properly relied on various badges of fraud to show actual intent to defraud or hinder present or future creditors. Wow. All right, let's see here. Have we made it through the general stuff? I didn't want to leave any of these good definitions behind. The effect of badge of fraud did not establish fraud per se, merely afford grounds for such an inference or conclusion. So let's look at the practice tip. We're going to get to section 26 and we're going to be closing this one out. Once a party alleging a fraudulent transfer demonstrates a sufficient number of badges of fraud, the burden of proof shifts to the defendant to prove that the transfer was not fraudulent in some states. But other states do not follow this burden shifting rule. Excellent. Good practice tip to know. Find out what applies in your state. And we got examples here. These are great. We could go on and on about this, but you could probably look at your local news to see some of these. Effective insolvency testing for, okay. Almost there. See section 26. So a lot of this procedural stuff here. We'll skip. Factors. Yeah, okay. We're insolvency here. Almost there. So, oops. And 24 effect. Almost there. We're just getting through this insolvency part. And here we go. Effect of lack of fair consideration. All right, this is a short one, but this is a good one to end on because I definitely want to get over this section right here. The Uniform Fraudulent Transfer Act provides that a transfer is fraudulent as to a creditor if the debtor made the transfer or incurred the obligation without receiving reasonably equivalent value in exchange for the transfer obligation, and the debtor's finances were precariously as defined by the Act. Similarly, the Uniform Fraudulent Conveyance Act forbids conveyances by one who is insolvent or will be rendered insolvent when the conveyance is made without a fair consideration by individuals, persons engaged in businesses, and persons about to incur debts beyond their ability to pay. Lack of a fair consideration is also recognized by the courts to be a prime factor in determining whether the transaction is fraudulent. So there we go. That's what I want to get over, the effect of lack of fair consideration, just to put this into perspective. And we're going to be going over a second part of this, which is going to have quite a different tone. I definitely want to get over this because we have to be familiar with both sides of this to be able to really look at the implications when the rubber does meet the road. That's why I find these practice tips we find here in AmJur very beneficial. And as you go deeper in, you find out even ways to determine dollar values of some of these tort cases and such that they mention. That being said, I want to appreciate everyone that's showed up here today. It's been a great enlightening review of this fraudulent conveyances and transfer. Remember, this is to educate and entertain, but mostly so that we can start to appreciate more of what the legacy has been left to us in the form of our style of jurisprudence, which is uniquely the American jurisprudence, a blend of time-tested ways of keeping any kind of contentions peaceful, and in a way that's been time-tested beyond any personal ideas, but one that's been a amalgamation of the most enlightened philosophical and lawful minds of the times, and it seems to have persisted this long as we can hold on to it, and this is how we do it. So again, I want to thank everyone for coming here and salute you all for spending the time to go through this, and I hope to see you all on the next one, which will be part 2, and we're going to get in, like I said, it'll be a whole different tone of this, and we really get to see the workings of what's going on in the courts today and how these conveyances are occurring both fraudulently and properly. On that, I would like to salute you all for coming, and I'll hope to see you all in the next one. Peace out.